protection of the institution from retribution from the executive by ensuring the reports of the Ombudsman only issued recommendations for remedial action. The Zambian Constitution, however, provides for a final decision for the Office of the Public Protector. We further recommend that the Council includes an eminent scholar from the field of academia. The inclusion of a member from the field of academia on the Council can offer a number of advantages. Educational expertise. Academics are generally familiar with teaching methods, curriculum development, and assessment techniques. Their expertise can contribute to the design and improvement of training programs at the Judicial Training Institute. Research and innovation. Scholars are often engaged in research and keep abreast of the latest developments in their fields. Their presence can foster innovation and integration of best practices in judicial training. Balanced view. An academic member will bring a fresh and balanced perspective to the Council discussions. They may present views from different angles than those with purely judicial or administrative backgrounds. On quality assurance, scholars are familiar with quality assurance processes in higher education. They can help set and maintain high standards in judicial training. On the functions of the Council, Section 7.2d provides for the Council to monitor and evaluate the performance of the Institute against budgets and plans. Our recommendation / comment is that while we fully appreciate the monitoring and evaluation law of the Council, Section 7.2d only provides for the monitoring and evaluation of the performance of the Institute against budgets and plans. We recommend that the evaluation include timely feedback from the judges, judicial officers, and staff so as to ensure quality training. A broader monitoring and evaluation system will help the Institute improve its operations as highlighted below. 1. Comprehensive performance evaluation. Monitoring and evaluation an institute's performance against budgets and plans is a fundamental aspect of financial accountability. However, it is equally important to assess the overall effectiveness and quality of the Institute's activities. It is recommended to expand the scope of the assessment to include not only financial parameters, but also quality aspects of training. 2. Stakeholder feedback. It is essential to include the feedback of judges, officials, and court staff in the review process for a number of reasons. A. Quality improvement. Feedback from these stakeholders can provide valuable insight into the effectiveness of training programs. It can identify areas that need improvement to improve the quality of training. B. Alignment with needs. Judicial training should be tailored to the specific needs and challenges facing the judicial system. Feedback from these directly involved with the judicial system can help ensure that training meets these needs. Continuous improvement. The regular feedback mechanism fosters the culture of continuous improvement within the Institute. By combining proposals and responding to the stakeholder concerns, the Institute can adapt and evolve to meet changing requirements. D. Transparency and accountability. Involving judges, officials, and court staff in the review process improves transparency and accountability. This demonstrates a commitment to involve all stakeholders in the assessment of the Institute's performance. 3. Improve the quality of training. The ultimate goal of the Institute is to provide high-quality training that contributes to the effective functioning of the justice system. By expanding the evaluation criteria to include feedback from stakeholders, the Council can ensure that the training offered meets the highest standards. In conclusion, Also the Public Protector recognizes the profound implications of the Judicial Training Bill number 14 of 2023 for the judicial landscape of our republic. The establishment of the Judicial Training Institute promises to be an important step towards strengthening the capacity and effectiveness of our judiciary. It offers a promising avenue for choosing existing skills gap, promoting consistency in the interpretation of the law, and raising our case law to the highest standards. A commitment to invest in the training and capacity building of the judicial officers is an investment in the fundamental principles of fairness and equality that underpin our legal system. With the passage of this bill, Zambia is on track to strengthen its legal infrastructure and ensure that our courts uphold the ideals of a just and equal society. Considering the potential benefits this has to our justice system and the pursuit of justice, the Office of the Public Protector endorses and supports the Judicial Training Institute Bill number 14 of 2023. This is a commendable step forward towards a stronger, more efficient, and a fairer judicial system for all citizens. Thank you, honorable members. That was a quick run-through.
Thank you so much. Honorable members may seek clarifications. Honorable members, if we can be very, very brief in the way that we're seeking these clarifications, and then we can ask one question at a time. We'll start with Honorable Chinkoli, and then Honorable Hamwanta, and Honorable Monsanje.
Thank you, Chair. Thank you, witness, for your valued, contribution to this matter, which is, before us. There's somewhere where it's made mention that your office should be, joined into the commission of the judiciary. I want to believe that your office is independent. It's an independent organ on human rights protections, who should not, compete with the court. I don't think you are competing with the court. So that being the case, if you are part of the commission, how are you going to work, bearing in mind that you also protect the human rights, and the court is very independent to determining whether someone's rights have been, abrogated, and so you are joined in their commission. How don't you think you'll be compromising the two institutions? I submit for now.
Thank you, honorable member. To answer categorically, it will not compromise the functions and operations of the Public Protector. The Public Protector, as a quasi-judicial body, complements the court system in the dispensation of justice. So, benefiting from the skills development that will be offered by the Training Institute will help enhance justice delivery by the also the Public Protector, because we've realized that in Africa there are not so many training institutions that offer specialized training for arms institutions. So with the coming of this Training Institute, it will effectively help the institution perform to the expected standards of the Zambian people. I thank you.
Thank you, Chair. Witness, in your submission, you are proposing to include, among other functions, the provision for conducting research, any inadequacies on the judiciary, existing laws or policies. One of the functions, as outlined in the proposed bill, is conducting research into judiciary, education and professional training, emerging fields of law and impact of judgment. Now my question to you, witness, is, don't you think this part, which is part B in your submission, functions of the institutions, do cover your proposal? I hope you have gotten my question. Thank you.
Thank you, Honorable Member. Yes, it does appear like it is covered. However, the emphasis was on the fact that we are alive to the fact that the Zambian judiciary has really been bashed, that the jurisprudence that comes from there does not meet the international standards. So we propose that we enhance that aspect of research so that we have jurisprudence that will stand the test of time and compete favorably at the international level to make Zambia a reference point without it being looked down upon. So that's why we re-emphasized on that aspect, though it sounded like it was repeating. Thank you.
Thank you, Chair, and thank you for the very comprehensive submission. My questions relate to one. Of course, I agree with your recommendations on 5C to identify training needs for the judiciary. I think that's correct and the correct way to start things. 5.1G, facilitate. Again, I agree with that. And the commissioning of studies. Yeah. I see also the other items you have further provided for in terms of what else should be covered. Now my question is, given that we've got the ZIARE Act that provides for professional development, don't you see that it could be a repetition between what ZIARE has in terms of professional development? Of course, it's only focusing on that by exam in its professional development, but actually in the Act it says to provide for continued professional development, which we don't seem to see much. Maybe they are just neglecting that aspect. So don't you see that this will be a repetition? And then we've got also the Magistrates and Judges Association. Don't they offer CPD to their members? And finally, don't you see your members of the Ombudsman being conflicted in going to learn or be capacity built in accusatorial procedures when actually you use inquisitorial procedures yourselves? Thank you.
Thank you, Honorable Member. I'll start with the last. What we propose is that if this training institute comes into operation, the public protector should be accorded chance to take part in formulation of the curriculum that will cater for the inquisitorial approach. Inquisitorial, to you honorable members, if I would elaborate, what happens is that the judge investigates and weighs the evidence that is gathered through the investigation and then makes a determination. When the ombudsman sits, we receive complaints or initiate complaints, initiate investigations. We do not bring the opposing parties at the same time as is the case with the courts. We will hear the complainant, then go to the respondent, and back and forth until we've gathered sufficient evidence to make a determination. So whilst with the courts, the judge sits and acts on evidence presented before the courts by the parties, the prosecution and the defense. But the ombudsman investigates on his or her own volition to find the evidence that will make the ombudsman make a determination in a matter that is at hand. So we feel the ombudsman being included in this training institute should be accorded chance to formulate the curriculum that should now be used whenever there's enrollment for ombudsman staff. They will be trained on that curriculum without being trained on the adversarial approach that the judges will be trained on. we've looked at this with a view of also making this institution financially sustain itself. If you recall, in my earlier submission, I did allude to the fact that in Africa, there's no single training institution that trains ombudsman staff, other than just a research center at the University of KwaZulu-Natal, which is not offering fully fledged training. The only training institutes are found in Europe. So we feel if the ombudsman curriculum is taken on board, this institution will be raking in good foreign exchange and to be able to sustain itself, because there are about 53 OMS institutions, national OMS institutions, and then there are these sectoral OMS institutions in other progressive society countries like in South Africa. They've made their public service delivery system more efficient by establishing sectoral OMS institutions. So we look at it, when we look at the aspect of raising money, it's a very lucrative, it will be a lucrative venture for this institution, because people will find it easier to come to Zambia to train their staff. Then on the other aspect, what was the other question on the same? The magistrates, the representation of magistrates. The public protector, being a quasi-judicial body, is the largest quasi-judicial body founded in the Constitution of Zambia, and we feel it needs to be represented on the council, so that the interests of other quasi-judicial bodies is taken on board, because we've seen the judges are represented, the retired judges, the High Court judges, the Court, and the Supreme Court. All these will be pursuing their specific interests. So there will be no one to speak to for the interests of the quasi-judicial bodies, the tribunals. And in Zambia, we've seen progress. The OMS institutions will be growing. Sooner or later, I'm sure this honorable committee, the Bank of Zambia, will be operationalizing their financial and banking services ombudsman. So we foresee a situation where, for Zambia to make progress, to have an efficient and professional civil service, sector-based OMS institution will be created, and hence, with the coming of the Judicial Training Institute, all these sectoral OMS institutions will need professional development, skills development. I think I rest my case, Honorable Member.
Honorable Minyoni, and then Honorable Chanda.
Witness, good. It's afternoon now. Oh, still morning. I'm taking you to part 3, the Council of the Institute. If you look at the Council of the Institute, all we have here is judges and judges. And in your report, you are saying you've got no problem with this. And you being the protector, sorry, it's the other one. It's not, yeah, okay. Okay, you being a public protector, when you look at this, are we not creating a monster within the judiciary where people will sit, form a curriculum, suit themselves, starting passing judgments against the will of the people? Because if you look at this, everyone is appointed, 80% or 90% appointed by one person, meaning they cannot argue with that person. And your duty is to see to it that such things don't happen. What is your take on this one? Thank you.
Thank you, Honorable Member. Our take is that, foremost, from the constitutional standpoint, we have no jurisdiction over the judiciary. But coming down to the composition of the council, that's why we've made a recommendation that we bring in someone from the academia to balance the council. Yes, there are learned High Court judges and judicial officers in the judiciary, but their specialized training is in interpretation of the law. When it comes to to training. We need an academician, those that are running the universities and other higher learning institutions. So the public protector's view is that for there to be balance, we've proposed that they broaden the council by bringing on board an eminent person from the field of academia, so that there is that balanced way in the running of the Judicial Training Institute. Thank you, sir. Thank you.
Chair, thank you so much. Witness, thank you so much for the submission. And I do agree that the public protector needs to be given the sort of space, and that it ought to take its rightful place. Maybe it's because you haven't risen to the occasion like Tulima Donsela, you know, that if you can shake one or two places and people know the public protector is actually here, you know. My question would be, I know one of my colleagues had asked regarding Ziali. Section 4.2H of the Ziali Act, that's Cap 49 of the laws of Zambia, gives the Ziali Council authority to provide a postgraduate judicial training for magistrates and judges. Don't you think the establishment of this institute then goes to create a duplication? Along the same lines, if this institute is to be, then would we be talking about amending the Ziali Act so that we don't have that sort of duplication? I submit, Chair.
Thank you, Honorable Member for Kanchivia. I think the composition of the Ziali Training Institute, if we recall historically, judges used to be tutors at Ziali. I don't think they really agreed to be subjected to be trained by the same institution where they were above, like. So the coming of this other independent training institute away from Ziali, with its composition, the way it's been formulated, it will bring about professional development without not taking much from Ziali, because currently what is obtaining at Ziali, lecturers are more or less on part-time. There's no full-time resource person there. When an institution identifies a training need, they will submit to Ziali and a quotation is given, then they'll run that short training. So the manner Ziali is run and the way we envision this other judicial training bill institute, this one will be more or less like from the way it will run, it gives confidence to all quasi-judicial bodies and the judicial system, because the lecturers that will be recruited from the staff that will be recruited to run will foster confidence. Then you did allude to the fact that, just for clarity's sake, that the public protector has been a little bit not taken its right floor. I think the clarity that I would like to give to this honorable committee is that the mandate of the public protector, South Africa and Zambia, are distinct, in the sense that in South Africa, the public protector investigates corruption, whereas in Zambia, the anti-corruption exists separately, and the ombudsman focuses just on maladministration. The South African ombudsman also investigates issues of the leadership code, which in Zambia is not the case. So that, from our operation now, it makes ours appear like it's not very aggressive, because the corruption part is tackled by the anti-corruption. Then the other mode, the Zambian system works in such a way that the public protector acts like a mirror to the government, where when investigations are done, the executive, the affected institution is called, or you sit with it and present a report and to go and make a redress for the wrongs that they could have, the misconduct, the alleged misconduct that could have happened. So going back to the Ziale issue duplication, I think we see more focus being placed on this Judicial Training Institute by the nature of its composition, the effort, and the specialized training that they do. While Ziale, yes, focuses on training legal practitioners, and also, yes, they do run CPDs, but the people that have attained CPDs at Ziale, they've always complained that the trainings are not properly formulated, owing to the fact that they do not have standing lecturers at the institution, because when a training program is about to be run, they go on the market and look for experts to come and conduct those trainings. So consistency is not there as one of the reasons, but I would like my colleague, Ms. Petita Mwanza, to add one or two words on the issue of duplication between the Judicial Training Institute and Ziale. Over to you, Ms. Mwanza.
Thank you, Chair. I think the Chief Investigations Officer has pretty much explained how we look at this issue. With regards to Ziale, it's more, the training is more centered on training legal practitioners, and the focus is just on that. And the difference with the training institute is that it will be tailor-made to train judges in particular, or officers of the judiciary. So there's that difference in the whole mandate, which sets it apart from Ziale. Thank you.
Honorable Chinkuli, Honorable Fove, and then Honorable Chand, and we'll conclude with Honorable Chand. Okay, you can go before Honorable Chinkuli.
Honorable Chinkuli, I apologize. Thank you. So what I made reference to witness was section 4.2H of the Ziale Act. If you're able to even get it on your Google, that's chapter 49 of the laws of Zambia. This section, yes, there's a component where Ziale provides postgraduate studies for lawyers as they prepare to be admitted to the bar. But this particular section provides that Ziale has the mandate, additional mandate, to provide a postgraduate judicial training for magistrates and judges. And the only reason this has not happened has been inadequate infrastructure and I think finance or funding. So I wanted just to make that clarification that they have this other mandate according to as per the Ziale Act. Doesn't the public protector view maladministration as a form of corruption? I submit, Chair.
Thank you very much, Honorable Kanchibia. Indeed, from the public protector's perspective, maladministration is the nesting pot for corruption, because when systems break down, people do not follow procedure, there is impunity. Maladministration is so broad, and because we have not effectively policed it, there is impunity where people think they can act the way they feel without regard to the established procedures and guidelines. This goes to affect even having the so-called rule of law, because we've seen a culture emerge in Zambia where if I know Honorable Chanda, I can, if I'm an employee of government, I'll go about abrogating the procedures with impunity, knowing fully well that I have the big brother, Mr. Chanda, to protect me. So the public protector views maladministration as a cancer, and if we are to curb corruption, we need to nip maladministration, because maladministration is committed on daily basis, starting from the highest office in the land. If you were to give an example that certain key positions have not been filled, that delay to fill position is maladministration. Failure to act, to take action when the nation wants certain action to be taken, that's maladministration itself. So really, maladministration really needs to be focused on if we are to win the battle against corruption. Failure to declare interest. We've seen many of these cases which the anti-corruption pursues. They emanate from maladministration. So issues of ethics and integrity. Every day the president is called to come and appear and account to the nation on values and principles. All those principles speak to the issues of people operating efficiently and upholding integrity. They touch on maladministration, because failure to observe those values and principles, we breed maladministration in society. Thank you.
Thank you, Chair, once again. I love democracy. Very interesting. Coming back to the bill, I just want to look at the aim of this bill. It's to establish a judicial training institute that will be responsible for training and capacity building of judicial officers. We end there. That is the aim of this. When it comes to the composition of the council, like my colleague has put it, it's judges. If you look at the certificate that will be issued to those trainees, it won't be a qualification. This is what we are told. Don't you think, looking at this, don't you think this the judiciary is trying to come up with an in-house training center that will, enhance the quality of service delivery of its staff? And if that being the case, why should other stakeholders want to come in and join themselves into something that is built for just the judiciary itself? I submit.
Thank you very much, Honorable Chinkuli. I think the need for skill development in the judicial system of Zambia cannot be overemphasized. Many times people have complained about delayed issuance of judgments, the quality of judgments. People have talked about the jurisprudence is made out of the judicial system. So this training institute will really go to enhance justice delivery system in Zambia when capacity is built, starting from quasi-judicial tribunals, the magistrates, up to the highest courts in the land. We expect efficiency and quality professional judgments rendered, which last for many years to come. If those that have studied law, Zambia has been learning primarily precedents from the English law. Why is it the case? It's because they trained their staff, they have quality judgments professionally delivered. So we equally aspire to have our judicial system make and operate to the highest standard in the world, not to just rank within Africa, but to compete favorably at the international stage. Our judges are very marketable, but you know, when judges are appointed to the courts, to the judiciary, they come from different backgrounds, from their law firms and other. So this training will try to also bridge the gap to try and make them operate to the required standard of the judiciary. So other bodies joining this is to help balance the interests of the Zambian people when the judicial system is well trained, equipped, starting from tribunals, because justice is dispensed in so many various categories. The ombudsman, like you earlier alluded to, the ombudsman equally is an institution of justice in that it plays a complementary role to the courts. It helps, if it's fully operational to the full capacity, it helps decongest the courts in that some of the court-mediated, court-supervised mediations, arbitrations can be done at the ombudsman. So you find when capacity is built, instead of clogging up the court system, some of the cases judges can refer to the ombudsman to help decongest the backlog which the ombudsman, which the courts may have. Ms. Mwanza can add.
Thank you, Chair. As we earlier explained, Article 244(5) imbues the public protector with certain powers as that of a High Court judge. So in essence, as he's explained, the public protector performs some judicial functions, and it's just important to have the office included in this training. And the bill itself talks about training, enhancing capacities of quasi-judicial tribunals. We feel it's important to include these bodies to this institution. It's not an issue of just making recommendations because we feel it's fancy to be a part of this institution, but because of the functions we perform, it's important that we're included to be part and parcel of this institution. Thank you.
Thank you, Chair. Let me take this opportunity to introduce myself. My name is Mlenga Francis Fuve, the Member of Parliament for the Good People of Chulubi, and also the member for this particular committee. The witness, I want to really find out how this institute would fit in the piece of, because I would like to believe that the institute is bringing to the table of the gaps that are supposed to be amiss in the delivery of justice system. And if that be the case, I have in mind that Zambia had the adversarial system. And if Zambia's adversarial system of dealing with issues to do with the delivery system of, if you look at the functions, in this case are judge-centered. The composition is judge-centered. Everything is judge-centered. Is this institute blind to the reality that if the trends are changing, there are other players who are officers of, who are friends of the judicial system, who need to be gotten on board so that experience can also be drawn from their standing of how they experience certain things. For instance, I don't mean to appease your institute, your institution, sorry, which I think is underutilized in Zambia when it comes to how it's supposed to be used as also a window of sorting out certain judicial questions. If we have adversarial, I know that later on you addressed a question from Honorable Musanje, which was talking about accusatorial issues and the other one, but I want to focus much on adversarial system that we have in Zambia. And I see, that's my opinion, that this particular institute has overlooked that the delivery of justice in Zambia is only judge-driven. I say that because, yes, I'm wrapping up. Yes, I say that because if you look at article, for instance, Article 18 of the Constitution and everything that is stipulated there, to me, this institute would have been, all of you stakeholders would gather there, and that should have been a meeting point. And the training should have sprung from that particular article. That's my submission.
Thank you very much, Honorable Fuve. Indeed, your observation is quite valid. The Ombudsman has proposed that it be included on the council so that formulation of the curriculum is not just primarily focused on the adversarial approach, but rather also to deliberately come up with training programs that will build capacity in other justice dispensing bodies, such as the Ombudsman. Indeed, your observation is valid. Justice is not only obtained from the corridors of the courts. Justice can be found also at the Lands Tribunal, at the Revenue Tribunal, and the Public Protector, and so on and so forth. So indeed, that's why we are lobbying this committee. You honorable members, you are the last bastion in lawmaking. You ensure that the amendments that we have recommended, that we broaden the functions of the council to not just focus on the adversarial approach, but rather look at justice delivery system in Zambia as from a broader perspective, will be appreciated. The honors, you are our last bastion in the country, to see to it that laws that are promulgated by this honorable house stand the test of time and meet the aspiration of the people. Hence, we've gone an extra mile to the extent that we appeared like we never understood that we are covered under the quasi-judicial training. We wanted to bring out the aspect that more emphasis was put on the adversarial approach, overlooking the functions of other quasi-judicial bodies, because they equally dispense justice. As I alluded to when I was responding to Honorable Chinkuli, I said that if the institution of the Ombudsman is fully supported, we've seen it's taking shape. Today, the office in Choma is being opened. Next week, they'll open in Dola and Luapula, Eastern, Western. Early next year, we'll be in Northern. So indeed, if the Ombudsman is fully supported, mediation, some of the cases which should not be clogging the court system can best be channeled to the Ombudsman. But that can be done if capacity is built, so that people have confidence to say that I'll get justice, which one can easily get from the courts. Besides, from the quasi-judicial bodies, the services are free. They come at no cost, deliberately designed to enhance access to justice, so that even the least in society who may not have the financial muscle to hire a legal practitioner can walk to the Ombudsman and say, I want my matter heard from this end. So your observation, Honorable Member, for Chiluvi on point. We will leave the rest to you, being our lawmakers, to defend this bill so that it incorporates the proposals which the Ombudsman has made. I thank you.
Thank you so much. So very, very briefly, Honorable Musanj.
Yes, it's actually very brief. I'm just wondering why I've not been invited to the opening of the office in Choma, considering that I've got cases with you from Kabanga area, where he comes from. The people who were beaten by the police and the other cases. So I deserve to be there. Thank you.
Through the chair, thank you, Honorable Member. I think the official opening where you will be invited is being planned. What I meant is that the office is setting up where they've moved the furniture and the staff have relocated. So once the administrative issues have been completed, the official opening to which you will be officially invited will be extended to your office. With regard to those cases you brought, they are being worked on. I may not divulge here. They are actively being pursued both from the Police Public Complaints Commission and ourselves. So we shall be, in fact, we've been talking to the area councillor. We usually give him updates on the progress of how the investigations are progressing. I think at an opportune time, we shall share with you the findings and the remedial action which the Police Public Complaints Commission will give. I thank you.
Thank you very much. And then I just made a summary on the best practices from other jurisdictions. Are you able to share with us?
With regard to the ombudsman perspective,
To the institute itself.
To the institute itself. Indeed, we've seen from other jurisdictions that their judges are well trained. They write judgments on time, and the judgments which are written of that repute, they build jurisprudence which forms curriculum for some of the law students, and it helps bring out quality lawyers on the market, because law is made in Parliament and also from precedents from the judges. So we recommend that, yes, as a matter of best practice, our judiciary should also have this institute to help raise the standards, as is the case with other countries. Because in Zambia, Chair, when we recruit people, we forget about them sharpening their skills. We forget about continuous professional development. So we are living in a changing society, so knowledge is changing. The economy is changing, technologies. So we need to keep abreast. For people to appreciate the skills which people have, we need to invest in capacity building. So this training institute, if they formulate the curriculum that is progressive, updating it regularly so that it's competing favorably with the other jurisdiction, then it will add value. It's my prayer that, I know people from the legal background, judges, lawyers, do not easily accept change. That is a fact. Judges and lawyers are very difficult people to accept change. So we hope they will not let the curriculum for this training institute be a cake. It's my belief, I think Council Mwanza will agree with me, judges don't easily they get to be convinced. So we hope with balancing the council, bringing people from the academia, they will push this council to be more progressive. I submit.
Just a minute, sir, before the colleague comes in. We wanted to know, are there specific countries with such training institutes that are successful that we can also look at?
Would you want to take that?
Yes.
Okay.
We have Kenya and Uganda, and our bill has pretty much borrowed some of the practices in these two countries that have successfully run or are running these institutions successfully. So we feel this is an institution that would be quite helpful to our judicial system and the quality of judgments. Thank you.
Sorry, Chair. Do you agree to the session that you resist change?
Lawyers or judges? I believe generally human beings resistible to change. So it takes time to get with the program. It's a human nature. It's human nature. Thank you.
I'm sure that was on a lighter note. Thank you so much. And thank you for your presentation. It was very, very thorough and very, very interesting, and it will assist us as we submit this report to the full House. And thank you for coming. Please do continue coming when we call upon you. And we also want to thank you for the other submissions you made on the 2 previous bills. We received them. They were written. We didn't sit with you, but we always look forward to these interactions. So thank you so much. Please do come again when we call upon you. And we will now withdraw the immunity that was bestowed upon you. Thank you. Have a great day.